A retired judge specifically designated to hear the fraud and forgery case against a Portsmouth councilman has officially recused himself.
Court documents just filed today show the judge consulted with the Supreme Court and showed good cause for stepping down. 13 News Now investigative reporter Laura Geller joins us with the details.
Well, guys, this latest shakeup in the case comes almost a year after retired Judge William Andrews was assigned to the case and just a few days after Mark Whitaker's trial was postponed again. So we wanted to know what this means for the case.
The special prosecutor expects to maintain the July date for the trial about Mark Whitaker, his church, its development company, and its federal credit union. We asked legal analyst Mike Goodove to put these new developments in context.
The trial had not started, so whoever the Supreme Court appoints will be able to step in.
There isn't a list of reasons a judge can use to step down. The recusal note only says good cause was shown.
A case isn't always the same case when it starts off, and so if a conflict developed that the court was unaware of, or the Supreme Court was unaware of, and the trial judge was unaware of, that became a conflict issue, this judge has to recuse himself, and he has no other choice.
With no new judge assigned, we don't know yet what will happen with this defense motion to disqualify the special prosecutor. Included in the motions, pages of the transcript from secret special grand jury testimony. Whitaker's attorneys requested the motions be sealed, but we found them in the public court record. Here, one of the investigators alleges about Whitaker and the credit union. That was his own piggy bank. This piece says the investigation uncovered at least one person who had no idea his personal data had been used on an application. The investigator alleges he never borrowed any money, never gave anybody his information. Whitaker's attorneys argue at the time of the hearings, the Commonwealth already knew the loans had been paid in full. They submitted this email to investigators, which says there were no loans outstanding when the credit union was liquidated in July of 2015. Less than 20 pages of the transcript, which is hundreds of pages long, were released in the motion. Sources say it does not paint the whole picture of the case.
And in that transcript, one special grand juror asked why the Federal Credit Union Administration weren't the ones to move forward with the complaint. The investigator responds the NCUA doesn't have the authority, but the juror points out officials didn't contact investigators. Investigators contacted officials. Laura Geller, 13 News Now.